Hey, good afternoon, everyone, and welcome to Meltzer Hellrung's December webinar, year-end immigration updates, and a look forward to 2026. We are going to give folks about another 3 minutes to join here. We'll be right back. Hey, we're running about 3 after here, so we're going to go ahead and get started. Well, thank you, everybody, for joining us for Meltzer Hellrung's December webinar, looking at immigration changes in 2025 and looking forward to 2026. A little bit about our firm, if this is your first time joining us. We combined an innovative service model with our legal team, proprietary technology, Voyager, our immigration platform, and we have a really creative group of attorneys to solve problems for clients. We have over 200 corporate clients, including Global 200, Fortune 500, venture-backed unicorns in our book of business. We were recognized by Crane Magazine in 2023 as one of the 100 best places to work in Chicago. We really take pride in our culture and our team here. We were ranked in 2026 by Chambers as one of the top firms handling immigration work in Illinois. And most recently, we were named as an Inc. Magazine 2025 Power Partner, which we're super proud of. I believe that just happened last month. Um, a little bit about our service platform for clients. We really focus on responsiveness in our firm. We answer emails on average in about 4.5 hours during a business day. We're very efficient in turning around cases or speed. And we focus on getting those transfers, those new employees on board, those cases filed within 10 days. So you can onboard those new employees as quickly as possible. We're very feedback focused at the firm. We rely or gauge our service on what's known as Net Promoter Scores or NPS scores, very popular in the software industry. Anything over 70 is considered to be best in class. We have 2 years running, 2024 and 2025, where we've been 90 plus. And then we don't just process cases for clients. We really work on program management. We partner with your organization, assign a dedicated account team, have regular touch points, and then establish SMART goals and rocks and things that we want to get to in your program, perhaps, better budgeting or reduction of cost or risk planning, a bunch of different things that we can accomplish across books of business. Just depends on what your needs are. Today, our presenters, my name is Matthew Hellrung. I'm co-founder and managing partner of Meltzer Hellrung. My specialty is scaling immigration programs for our high-growth clients via immigration policy and stakeholder training. I've represented clients, of all sizes and industries, filed thousands of cases at this point. And I also oversee our business development functions, human resources functions, software, finance, and our client services team. With me today is our senior counsel, Mike Turansick. Mike, do you want to introduce yourself?
Yes, good morning, good afternoon, everyone. Thanks for joining us. My name is Michael Turansick. I'm a 30-year plus practicing immigration lawyer. I have worked with complete range of corporate clients from startups all the way to Fortune 100 companies. Have spent a lot of time helping companies build effective immigration compliance programs, and have been spending a lot of my time the last few years working on immigration policy and advocacy issues.
Yeah, Mike comes to us from the American Immigration Lawyers Association out of Washington, D.C. He's our sort of backdoor into exciting information that's happening with the administration. We don't, as a pulling together our services, our folks, our legal team, our service philosophy and representing clients is our proprietary technology Voyager. We released this in 2023, I believe, or 2022, excuse me, been a few years now. And it drives process efficiency, transparency, and really is the centralization of all information for your immigration program. It's the one source of truth that you all, as human resources and perhaps general counsels, have access to. Your employees have dashboards where they can access their information and see where their cases are in process. And then we, as your immigration team or partner, have our attorneys and paralegals and legal assistants working in it from our side to process cases, push them forward, make sure all the information that we have for your organization is correct so we can manage your organization properly. We have dashboards, as I mentioned before. We have customized efficient workflows that are customized to the type of cases that we're processing. For example, an H-1B or a TN or a perm-based green card all have their very specific processes and steps lined out. Our most recent feature is an extensive immigration reporting function where you can report on any piece of information that is inside of this platform. More recently, we had folks receiving extra scrutiny or delay in asylum claims for folks from 19 different countries. We can pull a report and see which clients and individuals we're currently representing at any time that are citizens of those countries, and then reach out and develop risk management plans for those cases. And then we have a comprehensive knowledge center in the platform that includes collateral that covers, dozens of different types of immigration processes, collateral for human resources folks dealing with taxes and issues in terms of offboarding and onboarding and PIPs and a whole bunch of other things that would go on with immigration-related employees. And also our webinars and blog posts that we keep up to date. If you'd like, we'll stop here for a second. If you'd like to get more weekly updates from us, feel free to take your phone and scan the QR code. We offer weekly immigration updates right now and a weekly report that kind of summarizes all of the stuff that's going on week to week in immigration. There is a lot of it. So we try to make it efficient for you all to digest and send that newsletter out every Friday. It includes both things that are happening in immigration, things we think might happen going forward, and then updates on stuff that perhaps happened a few months ago. We also have our webinars that you can subscribe to. Obviously, if you're listening to us, you're here today, and additional reports and offers for different products and things that we're rolling out to help clients navigate the immigration process these last few months. Agenda today, we're going to cover quite a bit. The H-1B process, the registration process, what that will look like in 2026, what's happened in 2025 that will affect 2026, the $100,000 H-1B fee. I know we have received so many questions about this from clients and when and how it will apply. So we're going to thoroughly review this today. There's regulatory proposals for reforming the H-1B program in general, not just the registration process potentially. We'll discuss changes to student and OPT pathways. There's perhaps on the horizon an overhaul of employment-based green card categories. Nothing new, but from 2025, but DHS vetting and integrity initiatives. Everyone's heard of the Gold Card program. It seems that might be something that happens in 2026. So we'll spend a moment on it, why we think it probably won't work. And there are additional things like the $250 visa integrity fee that may be charged to consulates in the future, Project Firewall from the Department of Labor to increase scrutiny over H-1B programs, and then potential changes to the Department of Labor's wage level system for E3s, H-1B1s, and H-1B prevailing wages. Mike, do you want to start off with 2026 as a preview here?
Yeah, no, thank you. Thank you, Matt. I appreciate the lead in. I really have to say at the outset, with so much going on, it was really hard to try to manage that list down to something that we could try to cover in 1 hour. For example, we're not going to formally discuss the indefinite pause on benefits to individuals from the 19 travel ban countries. We're not going to talk about the public charge rule that was proposed a few weeks ago that could affect anyone who has ever at any point in their life accepted a state, local, or federal means tested benefit. And we're also not going to talk too much about the F1J1 rule that would create fixed duration status. Those are big issues. Those are big issues. But frankly, what we tried to do is put together a top 10 list, which is what we're going to try to cover in the next 55 minutes or 50 minutes or so. As you all know, because you're here and you live this every day, 2025 was unparalleled, in terms of the scope and pace of change. And while, the first 6 months of the year were really more focused on the border and on, removal issues, really the last few months have focused on the legal immigration area. And we have every reason to believe that 2026 will even be more intense in that regard. I mean, certainly, if you're watching the news or reading on the news on the internet, you can see national security concerns are top line issues right now. There are also issues about the economy and impact of foreign workers on the domestic labor market. And also, it has to be highlighted that immigration policy is going to be a major issue in the upcoming midterm elections. And it will definitely be used as an issue, driving fundraising, driving turnout. So expect immigration to be something that is a bright line issue in terms of who controls Congress for the next 2 years. So, really what I want to talk about is how, this is, going to impact those of us who are employers and employees, how it impacts our ability to maintain a competitive global workforce. I mean, these changes are going to impact how we hire and retain the best possible talent. And I've heard from employers and from colleagues around the industry that the real struggle is that we really want to do that. We really want to hire and retain the best possible talent, and foreign talent, when it supplements the U.S. workforce, is essential to doing that. But it's a time when the pressure is increasing, the demands are increasing, and frankly, budgets are not increasing. So it's a common concern. I just wanted to share that at the outset. Maybe let's move on, Matt, to the next slide. So
Yeah, we'll tag team here. So fast tracking the H-1B weighted selection rule. So this will affect individuals who are putting folks may affect individuals who are putting folks through the lottery in 2026. Essentially, the current lottery process is completely random. You either have the equivalent of a bachelor's degree, or a U.S. graduate degree. There's sort of two groups there. You have 65,000 folks. Actually, everyone that applies for the H-1B lottery is thrown in an initial 65,000 person lottery. Both U.S. master's degree holders and bachelor's degree holders. You get 65,000 selections there. Those folks who are not selected in that lottery, who have U.S. graduate degrees, are then put in a secondary lottery of additional 20% or 20,000 selection. So it is, but those lotteries are completely random. There's no weightedness based off of any characteristic other than you either have the equivalent or U.S. bachelor's degree, or you have a U.S. graduate degree. This rule, the registration process, attempts to change that. That was proposed in September 2025. Currently, comments are currently under review that were submitted. I think it was about 90 days thereafter where we could submit comments. It's possible that this will be implemented for the 2027 cap. The final rule will need to be published in January here. Essentially, what this does is it asks you, what we think will happen is when you register individuals for the lottery, you will have to state, basically the LCA SOC code and category that you intend to pay the person. And that category will be used, that wage level, excuse me. There are four, 1, 2, 3, and 4, 4 being the highest, 1 being the lowest. The higher you are on that wage level scale, the more entries you may get into the lottery. So for example, if you have a wage level 4, you get entered 4 times into the lottery. Whereas if you have a wage level 1 on the H-1B lottery submission for an employee, that person will only be submitted into the lottery 1 time. So it would create a weighted system where individuals that are being paid the higher wage levels are more likely to be selected than those being paid at the lower wage levels. Why is this a problem overall? Because the H-1B program often serves, folks that are just out of school on their F1 OPT program, that are probably wage level 1 or 2 at best, because they're generally entry-level folks that have, don't get me wrong, advanced degrees, but essentially entry-level folks. So there is the expectation of a litigation or injunction here after the final rules published. We can't sue on it now because we have to wait till it's published for it to be sue. The DOJ is likely to request a stay of injunction, and the potential impacts for 2027 are up in the air at the moment. My personal opinion is that I don't think this will be in effect for the 2026 lottery for fiscal year 2027. Mike, what do you think?
Yeah, no, I think that's right. I just, as a way of background on the tactics here, there have been discussions around litigation pretty much since this rule was published in the Federal Register. So that process is ongoing. As Matt said, we can't do anything until we see the final rule. You can't sue on a rule that hasn't been published yet. But I think the anticipation is pretty quickly after the rule is published and final, unless they do something completely different, there will be litigation filed. it will be filed in a court that has a history of being more favorable to enjoining these sort of extra statutory actions by the administration. And very possible that an injunction will be granted. The wild card here tactically is that the government knows this. They are expecting litigation, and they're probably also preparing a temporary stay order going to an appellate court. So, do they find a judge in an appellate court that's friendly to them and try to get this stayed? We don't know. I agree with Matt. My headline prediction here is that they're going to try to get it done. They're going to try to get it done either later this month. And when I say done, published in the Federal Register later this month or early in January. There'll be an injunction issued in January, and it won't get, they need 60 days to publish the rule, so it won't get done in time for this year's cap season. That's my prediction. But this is something we're watching on a daily basis.
Yeah, and this highlights a tactic that the Trump administration has used for quite a while now, which is like it's basically shotgun approach of publishing rules and executive orders. They're inviting challenge in the courts, and then they're essentially allowing the courts to tell them what is legal and what is not legal. I think this is just an example of another kind of rule that's been pushed through kind of haphazardly, very quickly, will likely be published. They know there's going to be litigation. And the administration is just saying, well, you could play it out in the courts. You tell us what we can't do, essentially, which is why I do think injunction's likely in 2026, making, highlighting the fact that folks that do stay the course here with lottery selections, we do think there's an opportunity to have higher lottery selections than ever in 2026, given all of these things are going on in immigration. We think it's going to scare a lot of employers away from submitting lottery applications, which means there'll be a drop in lottery applications and a spike in a rate of selection in 2026. Something affecting Mike here. Do you want to take the H-1B fee,
Sure, I
that
think,
lottery process
yeah,
and that
I think
notion?
absolutely, Matt. I think most everyone on this call, I assume, is aware of the fundamentals of the $100,000 H-1B. But just to summarize, it applies to new H-1B petitions filed for beneficiaries abroad who don't have valid visas. It's been in effect since September 25th. It hasn't really been implemented broadly, although there have been some requests for evidence requesting payment of the fee for cases that were filed sort of in this fuzzy interim period where it was after September 21st, but before there was official guidance. But really, it hasn't had any traction yet, but we expect it will have, if it becomes, if it is ruled legal, it will have major impact on fiscal year 27. Headline here, though, is that we don't expect it to become legal ever. It is an illegal fee. In fact, the litigation that is moving forward for the U.S. Chamber lawsuit, the government just submitted its reply brief on Monday. I just reviewed it this morning. There are no surprises there. They're arguing that the president's decisions are non-reviewable and their emergency authority allows them to do almost anything they want. Nothing that we haven't expected. The Chamber's reply brief is due next week. So, at that point, it'll be with the judge. And there's possible that the ruling will happen possibly later this month. But I think with the holidays, it's even more likely that it will happen early in January. So I'm thinking that, we should have an answer on the Chamber's lawsuit. Keep in mind, there's another suit out in the Northern District of California, which is still working its way through their briefing schedule. But we should hear on the Chamber's lawsuit possibly by early January. And what we highlighted here is that, make sure, just as a sort of proactive, sort of protective measure, contemplate in-country change of status because the fee doesn't apply there. Contemplate other options as alternatives wherever they exist, and thoroughly review immigration history of potential H-1B hires because they've made it, the agency has made it clear that if there are prior status violations, any application for a change of status or extension of stay will be denied, which will trigger that employee and kick them over into the fee. So just keep that as the background. I think this fee is not going to be ruled legal, but again, their litigation strategy will play out over the next few weeks.
Yeah, I'm in agreement, Mike. I do think that the litigation has a pretty strong possibility of getting an injunction preventing this from going into effect. Although likely it will scare off. I think it has. We've seen in a few instances scared off employers from sponsoring H-1B lottery employees for next year. There's a regulatory proposal reforming, potentially reforming. So now we're going to move to things that we we think will may likely be proposed in 2026. This is up to this point of things that have happened in 2025 that are spilling into 2026, certainly affecting the primarily the H-1B lottery or the H-1B program. There is anticipated regulation that will come out in 2026. There are grumblings of it. Mike, I'll allow you to comment here as well, but it will revise the eligibility for H-1B cap exemptions. I believe that would apply to cap exempt employers. Um, it will potentially apply greater scrutiny to employers with prior H-1B violations. So these are bad actors, employers that have misused the H-1B program or committed fraud in some way, and likely increase oversight of third-party placements and off-site work arrangements. This third point is nothing new. The Obama administration actually cracked down on this in 20, I want to say 14 or 16. It came back a bit with the most recent H-1B rule that Biden implemented before he left office. Just again, staffing arrangements where the individual is an H-1B employee employed by a third party, but on site at someone like Boeing or some large company. Those are the individuals that be affected by this. Enforcement impact, more RFEs, more notices of intent to deny. That's what a NOID is. Our RFE is a request for evidence after a case has been filed. And they're keyed to probably violation history, including related entities previously. So they're going to go back into documentation, perhaps dig some of this stuff up. Stricter documentation around right to control for these remote employees or staffed employees, job location, client site assignments. Then potentially a higher risk of denials for staffing and consulting firms here. I would be hesitant and say most likely staffing firms and previous offenders. These are the third parties that are in the business of staffing individuals, whether it's software or other skill sets on site for medium to large size corporations. The publication of the rule is likely in 2026, although we don't have a specific date, and then the actual finalization of the rule, which typically takes another 3 to 6 months thereafter, is uncertain, but likely in 2026. Mike, any comments there?
Yeah, just by way of really quick background here, this information is drawn directly from the regular, DHS is required twice a year to list its regulatory proposals. And this information is drawn from a somewhat cryptic description of this proposal that's working its way through DHS right now. So these are the issues that were highlighted in their very brief one paragraph blurb that they published in their DHS regulatory agenda that was published in September. So this is something we keep an eye on. I agree with Matt that there's a lot here that is sort of building on things that have happened in the past. I think we'll see an increase in requirements for statements of work and contracts for third party placements, much more detail about those off-site arrangements. And really, this is all going to be covered in the context of protecting U.S. workers' wages and job opportunities and working conditions.
Thanks, Mike. So we'll go on here. So we'll be mindful of time. So we have challenges to student pathways. So these are students that come to the United States, go to school here, and what is either known as F1 status or J1, depends on the school and the program. So these are individuals that are in school right now, and then as they graduate, they get work authorization through optional practical training or OPT. Mike, what's happening there?
Yeah, this is another one that comes from that regulatory agenda, and highlight here, the USCIS director has been a longtime, very vocal opponent of the concept of optional practical training. OPT, STEM OPT, all the same for him. He thinks it's not consistent with the statute and not something that USCIS should be in the business of authorizing. So that's the backdrop. The head of USCIS thinks OPT should not exist. So this proposal is working its way again through the regulatory process. From the short description, it's very likely that this proposal will include, a shortening or eliminating of STEM OPT. It could also narrow the list of eligible majors, fields of study, impose more requirements on employers, more audits of employers. There was also a possibility that it will remove tax benefits for Fs and Js. Really just overall tightening of oversight and compliance, requiring employers to submit more detailed training programs and showing how they link to the job. So I think what we're looking here looking at here is a proposal that will be introduced as a notice of proposed rulemaking with a 30-day comment period that will, in an attempt to wind down the utility of the concept of optional practical training. Our last comment is, this is something that is open to public comment, and there is a procedure for all of you on this call to explain to the agency how this will impact your organization, how this will impact your ability to compete globally, how it will impact your talent workflow, your access to global talent. So I encourage you when this comes out to take a hard look at it. Contact us if you have interest in writing a comment, something I've worked on many, many times. And certainly, I think it's time for the government to hear the impact of some of these proposals, including one that would shut off a valuable access to talent stream.
Yeah, I mean, I think that there's likely to be litigation on this again, should anything get close or published. I'm sure this will be caught up in litigation probably until the end of the administration, one way or the other. Okay, let's move on. So regulatory overhaul of the employment-based green card category. So background here is that the employment-based green card categories range from EB1 to EB2, EB3, EB4, and EB5. They all correspond to different types of green cards. They're all either investment or employment-based for the most part. There's been an oversubscription of these categories. Every year, there's only about 1 million green cards that are available, which is dictated by a statute of Congress. Across that million that's available gets spread across all the employment-based categories, or all the actually green card categories in general. And it trickles down to EB1, which is the highest, EB2, which is the second highest, EB3 is the third highest, and so on and so on. For many, many years, there have been many more applications for green cards in these categories than there have been green cards available. So there are large backlogs for particularly EB2 and EB3 categories. So you have individuals that have been living in the United States on perhaps H-1B or another type of work visa for 5, 10, 15 years waiting because they already have an approved I-140 green card, essentially to complete that third and final step adjustment of status. So here they're talking about revising the evidentiary criteria for the EB1 extraordinary ability category, particularly outstanding professors and researchers. EB1 has 3 different categories: extraordinary ability. The second category, EB1B, is outstanding professors and researchers, and EB1C is the multinational manager executive category. So we're talking about the extraordinary ability and outstanding professors and researchers category here. There could be stricter standards for the EB2 national interest waiver. This is a track that a lot of folks have been using lately because it skips the employment, the perm process or the labor certification process. The reason being the individual is doing something that's significantly in the national interest of the country and therefore should not be held to labor market standards in a labor market test that happens in a labor certification. There are certain requirements that the individual must prove that they're well situated, that they have the knowledge that going forward they're going to be carrying out this work that's in the national interest. And they're proposing more rigorous documentation of achievements, the impact of the national interest work, and also more heavily scrutinizing the national benefit that's essential to that NIW process. There could be greater potential for scrutiny of degree requirements in the EB3 category for professionals. EB1 is your outstanding, it's not sort of education based at all. It's essentially, although there are sometimes significant education components of the category, it's mostly based off who you are and how amazing you are as a person, and your professional achievements. EB2 and EB3 are very much dictated by degree and years of experience requirements, and EB3 being the lesser of the two, and has a little bit of looser degree requirements than EB2, for example. So there may be a tightening of what degrees would actually be considered the equivalent of a bachelor's degree in the EB3 category, for example. The timeline for the proposed rule is sometime in 2026, possible rule, finalization of the rule in 2026. Again, this is something that's possible on the horizon. I would expect that any significant changes in these rules after comment and publishing will likely hit litigation from the immigration community in some form or fashion. Mike, what are your thoughts?
No, I think that's right. I think overall we will review, respond to the notice of proposed rulemaking, comment on what we think are areas where it's inconsistent with the plain language of the statute, and keep in mind that agency discretion to implement statute has been really narrowly, restrained in the last couple of years by Supreme Court decisions. So there will be some more opportunity for us to really try to challenge some of these provisions that go beyond sort of the four corners of the statute. But what's really going to be happening here, I think, is that they're going to be focusing on those categories that don't run through the perm labor market test. There is, I think, a general sense that these categories for extraordinary ability, national interest waiver are, if you will, to use a football term, an end around sort of the labor market test process, which is designed to protect U.S. Workers and wages and working conditions. So I would say we'll see a lot of detail there in terms of more rigorous analysis of eligibility in those categories. We'll also, I think, see more detail on successorship and interest issues, ability to pay, what constitutes a bona fide job offer. There'll also be, I think, some more authorization, sort of emboldening the agency to do more site visits in connection with these petitions. So I think, this is a rule, that will be adapting existing legal guidance and at the same time making it more challenging for individuals to obtain permanent residence outside of a labor market test.
So DHS vetting and integrity initiative. So not only there some of these. So the agenda that we've just laid out is what is in the DHS's proposed agenda for 2026. I'll highlight that this is done every 6 months, right, Mike, or every year. There are often a lot of initiatives, that are input in here to try to give notice to folks that what's upcoming. Most of them are never accomplished. Most of them are actually never published, or they never get to them, or something else happens, for example. So we're being these are prospective changes coming out in 2026, and we'll certainly keep all of you updated as they potentially roll out. The DHS is pursuing additional vetting and integrity initiative. Mike, do you want to tackle this?
Yeah, and to your point, Matt, the issues that we just highlighted were listed in the spring 2026 regulatory agenda. So they've been hanging around within the agency already for 6 months. So yeah, I think the one thing I would say is that these initiatives are always established sort of a target date, and almost never are those target dates ever really adhered to closely. Although if it's a priority of the White House, you might see a little bit more alignment with some of those dates. So I think the big issue here in terms of DHS vetting and integrity initiatives is that this is going to become more prevalent and more obvious to the employment-based community in 2026. One of the big issues that we're starting to see more frequently is interoperability of the agency databases. There's more coordination between state and labor and DHS regarding the information that they have access to. And a lot of this information is being analyzed and compared and really structured and organized with the use of AI. AI has become a very significant and growing tool that the agencies are using to help them analyze the massive amounts of data they have. And I'll just give you a really quick, headline. I saw a situation, not a client of ours, but a client of a colleague, friend of mine, where they had received an RFE with respect to an immigrant visa petition. I believe it was a second preference petition, where there was a question about inconsistencies in job duties between the application for labor certification and a non-immigrant visa application 7 or 8 years ago. So there's that level of data sharing and analysis going on. And again, it's being facilitated by artificial intelligence tools that the agency is using. So I think that we're going to see more of that. We're going to see more efforts to challenge cases on the basis of some of these inconsistencies. AI is going to become a bigger part of the process. And it's something that the lawyers, the Immigration Lawyers Association is looking very carefully at to make sure that the agency is not abandoning its responsibilities to actually review cases and exercise discretion and ceding that to AI technology tools. The last thing I'll mention is, we are getting into some very worrisome areas with respect to the agency's use of technology. And if you have a moment, I'm not going to dwell on it right now, but search the term mobile fortify. And I'll tell you what that is. That is a phone app. That is a phone app that is being currently used by CBP and ICE to verify the immigration status of individuals based upon a scan of their face or of a fingerprint. So while we all understand that when you're entering the United States from one of the international airports, and you're walking down all those long corridors, which everyone, pretty much every airport in the United States has for international arrivals, your face is getting scanned. Those cameras up there are not just security cameras. They're doing facial recognition technology before you get to the kiosk and talk to the CBP officer. That's been happening for years. It's not unreasonable to have your privacy examined in that context. But what this is doing is allowing officers on the street to scan your face and do what would be a digital stop and frisk. And really, there are concerns about what are the standards and what are the rules being applied to those incidents. And I would encourage you, if you're really interested, you can search TikTok video mobile fortify, and you'll see, I think, a pretty intense interrogation of several teenagers for having no other triggering factor other than they were riding their bikes in the middle of the day during a weekday, and they were pulled over. They were pulled aside by masked CBP officers in a black unmarked car. It's actually kind of chilling to take a look at it. But that is something that we'll be looking at, and we'll be carefully monitoring to make sure that the agency is complying with the Constitution.
Yeah, I think there's massive constitutional questions here about due process, probable cause, exigent circumstances, a whole bunch of different things, unreasonable searches. Definitely going to be a lot of, I think, constitutional cases coming up here over the next 2 or 3 years. The one thing I will say is I spent a good time of my law school career in China, and the only place I've ever felt or seen something like that happen is in China, where they would have black marked Audis would disappear people sometimes. We saw it happen several times in some of the small villages we were in. That's scary. Here we go, the gold card. So I think the gold card's been talked about by President Trump for quite a while now. It was, I think, initially proposed as a way to generate revenue for the administration. And there seems to be some more legs to it here in 2026. It kind of was announced, but then went away. There didn't seem to be any work done on it, but 2026 seems to be a potential anticipated implementation date. It grants permanent resident to foreign nationals who can pay a large gift to the U.S. government. Perhaps $1 million for each person. I think I heard 5 million as well, Mike, in there, something like that. And this would include the principal beneficiary that applies, as well as any dependents. Potentially a corporate gift would qualify for 2 million for the principal beneficiary, 1 million per person for any accompanying dependents. The question is, how do you square this? Because typically, green cards like this or new things that happen that are significantly a departure from existing regulations have to be done through an act of Congress. So they are what categories are you in? You can't create categories, so you have to shoehorn it into existing categories. They're looking at potentially adding this to the EB1A, extraordinary ability preference, as one of the qualifying factors, which would require a rule to revise that regulation. Second would be the EB2 exceptional ability and or national interest waiver that we discussed previously. Again, that would likely take a rulemaking to make effective, and they would have to change the current regulations that dictate those. Mike, what are your thoughts here? I mean, implementation date, late 2025, early 2026. I mean, this has been on the docket for, I think, more or less since Trump was elected. We haven't really seen much happen to date.
So yeah, I mean, I think the trigger dates are really in connection with the same day, actually the same day as the $100,000 fee executive order. Just before he signed that order, the president signed an order authorizing the agencies to pursue this Trump gold card. And the information that's on the slide here really comes from an advanced copy of the petition form for the gold card. It's called Form I-140G, and it really doesn't provide any guidance on any of the issues that Matt just talked about. It just says, there are 2 ways to qualify: an individual gift, quote unquote gift, and the language is gift throughout the form, of $1 million for each person. So a family of 4 would have to pay $4 million. And then a corporate gift of $2 million for the principal beneficiary, and then $1 million for each accompanying dependent. Now, it indicates that applicants will have to qualify, they have to check a box on the form. So I'm applying in the first preference category, the second preference category, national interest waiver. And I think Matt is absolutely correct. The general wisdom is that there will be some regulatory change that would say, for example, in the first preference extraordinary ability category, just like a Nobel Prize, making a gift, quote unquote, gift of $1 million is sort of a de facto qualification for the category. We don't know. There's been no guidance on this and how people will qualify in the second preference category, which is why I think there's very high likely that individuals who will be adversely affected by siphoning off visas in those categories who've been waiting in line for a while now will likely sue. There's a probability that there'll be litigation in that regard. Again, other than a $15,000 application fee and instructions that for proving source of funds for the gifts that closely mirror the EB5 categories, we really don't know how this is going to be implemented. But it's something that, because there was sort of a 90-day implementation target from that September 19th executive order, we're keeping an eye on this to see what happens over the next couple of weeks, because that could come through later this month.
Yeah, I mean, this is a simple adding more demand to an already choked off existing supply. It's going to make, I mean, to Mike's point, I think there will be a lot of litigation on this for folks that are already in line, have been waiting, some years or decades for green cards. This would affect their ability and make their basically the line that they're waiting in would be much longer.
Philosophically, I don't think we really have a problem with them, creating additional permanent residence categories. If someone wants to do this, God bless them. But I think taking it from existing visa categories where individuals have been following the rules and doing it the right way and have been waiting in line, I think that is where we're going to have some friction and then therefore litigation.
Yeah, I agree. So we'll move on here. I should be mindful of time. So the $250 visa integrity fee, Mike, you want to tackle this one?
Just to highlight that, this is already technically in effect. It became effective at the beginning of the federal fiscal year on October 1st, but the agencies haven't issued any implementation guidance about how it's going to be. How it's going to be collected is probably going to be easy, but there really is concern about how refunds will be issued, and that I think has been sort of the stumbling block in keeping this from being put into effect, because one of the rules is that if you comply with the terms of your admission of your visa status, you are entitled to a refund of this visa integrity fee. Now, the government's not really good in any context that I've ever experienced in my career working with them at refunding money. So really good at taking it, not so good at refunding it. So it's something to keep an eye on. I think that there is a concerted effort to get this done in Q1 of 2026 so they can start collecting the fees. So do not be surprised. Do not be surprised if something happens on this, January, February, and there are procedures where applicants for visas are going to have to pay actually $250 per visa. And it really is a per visa charge. So it'll be done in connection with an application at a consulate for a new non-immigrant visa.
Yeah, I just want to highlight this will not impact, applications that are submitted to the USCIS. It will only impact getting those visa foil stamps in passports at US consulates abroad. Now, that doesn't necessarily need to happen, every single time you get a renewal. It's typically how often is the individual traveling, and is their current visa stamp expired? Project Firewall. So this was announced, I think it's one of the executive orders, I think in March or April that came through on immigration. It started in 2025, the major H-1B enforcement initiative that's been launched by the U.S. Department of Labor. To be clear, the U.S. Department of Labor has generally always had these powers and responsibility for one, they publish the prevailing wages for positions and locales across the United States to make sure that the immigrant workforce on H-1B, E3, H-1B1 is not undercutting the salaries of U.S. workers. They are also responsible for public access file maintenance, which is sort of a notice requirement whenever you file what are known as labor certification applications for these various visa types, H-1B, H-1B1, and E3. They've announced this initiative as like a, sort of a retooled enforcement effort designed to quote unquote protect U.S. workers. The idea here is that they'll be more proactively investigating employer compliance with the H-1B program. Now, the USCIS has always done this as well through the Fraud Detection and National Security Division, FDNS. Even the Department of State has some investigators that can sort of check on wages and H-1B compliance during the visa stamping process. But we're seeing here, what we think will be more of a concerted compliance effort towards public access files. Public access files are those files that you need to keep. We do this for our clients and have them available upon request. Sometimes immigration providers will have you create this as the employer and keep it on site or digitally someplace. That's where we see this enforcement initiative going, very much like potentially I-9 ICE audits issued. It could have public access file audits issued by the Department of Labor. The goal here is to try to increase enforcement, detect wage violations employers are committing with H-1B employees, misclassifications of things like wage level or perhaps SOC code, which is a job bucket that you have to throw every H-1B, E-3, or H-1B1 job into, and then the misuse of H-1B workers in certain circumstances. Um, I think the backdrop again is to ensure that U.S. workers are not being displaced or undercut by H-1B hiring. Of course, I don't think that's really ever been the case, given that there are many, many more H-1B lottery submissions every year than there are spots. There's a massive demand for additional tech talent, STEM talent in the United States. And if you pull this back to just educational levels, it's looking at just supply and demand of the U.S. economy. The U.S. is not graduating enough STEM students. We have actually been importing STEM talent into the United States for decades now, which you can see through a lot of the large tech companies, including I think about 50 of the top AI companies right now. I think something like 80% of those companies have at least one immigrant founder or more associated with them. So we've been doing this for quite a while. But again, just a sort of retooled initiative by the Department of Labor to emphasize H-1B compliance, basically the rules that are on the books already. And we see, PAF or PAF compliance, public access file compliance, is kind of being the centerpiece of this. And I mentioned before here, greater pressure on employers to maintain accurate real-time LCA compliance. Those are the PAF files I just discussed. Data-driven audits, document requests. I think, Mike, the thing that's interesting here is how this plays into the rest of the regulatory agenda, as you mentioned before. These agencies are sharing more data in between them. Could be that, if you get a complaint, Department of Labor may show up for a public access file audit. A few weeks or months later, you might have ICE show up for an I-9 audit, for example. What are your thoughts there?
Oh yeah, no. And actually interconnecting this with a few slides earlier, the proposal to increase scrutiny of H-1B employers who have a history of violations. This is the direct connection. If Project Firewall, through a proactive investigation, and by the way, most investigations to date have been complaint driven. So this gives the Secretary of Labor and all the other agencies that are part of this multi-agency effort the ability to conduct independent investigations of employers, of industry sectors, and really, yeah, as I said, the LCA is the LCA public access file is the start of the investigation, but really they're looking at it to go beyond that, to make sure that workers aren't misclassified, that there are, that they're doing the job that's in the petition and in the LCA, and that U.S. workers are not being adversely affected by the employment. So it's really all about protecting U.S. workers. So yeah, absolutely. So someone who is going to be found guilty of a violation here, there'll be a ripple effect across lots of different areas. But I think there's a direct connection to H-1B.
Yeah. And I would highlight, so a lot of things we're talking about and a lot of these policies are being announced as things that the government's doing. We're educating you all in this process, because you're hearing about this stuff. We want to clarify as best we can right now some of these things that we think are likely or unlikely to happen. There is litigation that will almost on every one of these provisions that will likely happen going forward to either delay or stop them or partially have them implemented to some degree. Mike, I want to another key factor of like how well these programs or rules may be rolled out is funding, right?
Yes.
And how, like, you can say all you want about increasing enforcement at the Department of Labor, but if you only have 20 inspectors and you're not giving them any more money, there's not going to be a lot of increased enforcement.
Thank you for reminding me. There were two things I wanted to add here. That there are some reports of very limited investigations under Project Firewall that have happened. So it's really just a small number so far. But that point is accurate. I've talked to individuals in DC, and they said, take a look at the budget bill and see how much money is allocated to Project Firewall type investigations. If it's in there and there's money in there, you can expect it to increase in 2026. If it doesn't make the cut for the budget, it's exactly as you said, Matt. This is going to be sort of the paper tiger. It'll happen, but on a very diminished basis.
Yeah, and I would say that applies to most of the provisions we're talking about today, whether it's rulemaking processes or other things. It's, is there going to be litigation, of course, across all this stuff? And then how is the government actually going to execute on this high level strategy? I mean, strategy is nothing without execution, right? We learned that in the legal profession and business. So we'll wait and see what happens here. Potential changes to the Department of Labor's wage level system. So, as a background here, again, the Department of Labor publishes a specific via location where the person is working, the job that the person has, and then within that job category, there are four different wage levels for H-1Bs. E3s, H-1B1s, we as attorneys take a look at the job description, the level of seniority, and generally tie it to a specific wage level. There's a more precise calculation that happens if we need to. Um, but they're talking about changing these wage levels or increasing the potential minimum wages or how the calculations are done for these prevailing wages amongst these four levels. Mike, what are your thoughts?
Yeah, I mean, I think again, this is something that the president put into that proclamation for the $100,000 fee, sort of as a paragraph towards the end that didn't get a lot of attention. But I think this is something that we could very easily see sometime this year, primarily because in Trump 1.0, they did this. There was a regulation that was promulgated that dramatically changed the four wage levels for H-1B and the perm process, and they increased them rather significantly. Now that rule was ruled illegal for very technical reasons relating to how the head of DHS was appointed, not substantively. But that rule is still out there. The text is out there, so I could see them, sort of trying to take that rule that exists, update it, and promulgate it as a proposed rule sometime in 2026. Now, just as a benchmark, what it would do, it would really significantly increase level 1, 2, 3, and 4. So, for example, level 1, which is the continuum of salaries, the level 1 was at the 17th percentile. That proposal would have moved it all the way up to the 45th percentile. So anyone who is entry level would almost have to be paid the median wage for the occupation. And then for level 4 on the other side, it was level 67, or it is level 67 now, and that rule would have moved it up to the 95th percentile. So it really will make it much more complicated for employers to file for LCAs, file for perm applications. So that's something I would really keep a close eye on because the regulatory infrastructure already exists.
Yeah, and to that's the tail end of everything we're talking about today. There will likely be litigation all over this if proposed and ultimately implemented as there was the first time. Let's take a look. Let's move up. Excuse me. So key takeaways for 2026, and then we have a few Q&A here that I think, and
Yeah.
forgive me, I didn't mention in beforehand. We've been moving pretty fast today, but we are recording today's webinar. The copies of the deck that we're using, as well as the recording, will be sent out to everybody that registered. We have a Q&A function. If you have questions here at the end of the presentation, Mike and I will stick on for another about 5 minutes or so here and answer as many Q&A questions as we can. And everything we provided today is informational only. If you do have a legal question or something more specific, feel free to reach out to us directly. Immigration is incredibly fact specific right now. It's dizzying sometimes, the hole you have to go down to get to the right answer, given all the changes that are happening. So feel free to reach out to us for a consultation at our webpage or at our website. You can also, I think we have a contact information for Mike and myself after on the next slide. So Mike, let's wrap up here and try to get
Yeah.
to a couple Q&A with 2026 takeaways or what you can see happening in 2026.
I will do three really quickly. One, I think this year, the changes that we've discussed regarding the H-1B may not affect this cap filing season. However, the future is uncertain. I'm sharing with clients when asked that this may be the best opportunity to get entry level professionals into the H-1B category for the next several years. I'm also telling clients now is the time to review your LCA public access file, review your I-9 files, and make sure you're in total compliance. The agencies that are going to be enforcing these provisions are going to be unforgiving in their analysis. And also, those changes to the employment-based first, second, and third preference categories may take effect sometime later this year. Again, there may be litigation, but one thing that is clear is that the agency throughout its history has applied the rules in effect at the time the application or petition is filed. So if you're pending, you're under the existing sort of regulatory regime. Whereas if you wait until the rules taking effect, you may have additional requirements. And then last, I said three, I mean four, is that really need if you're really concerned about any of the issues that we've highlighted, the time to get involved is now. And either participating directly or through industry organizations or organizations like the U.S. Chamber of Commerce, which is a strong advocate for the business community.
Yeah,
Let's go to question.
I will second all of those, and I will say, I highlight here it's 26 is not all doom and gloom, and it would highlight that there are some opportunities employers can take advantage of. And just focusing on the advocacy component that Mike mentioned, while the Trump administration is, kind of holistically against immigration, we've seen, President Trump change his mind pretty quickly on certain issues once there's been sort of a business case or a money case laid out for it. Including, I think he was saying we're going to get rid of the F1 program, and Trump came out and said, well, if we get rid of that, all the Chinese students that are funding U.S. universities, there'd be a crash in a lot of these universities' funding schedules. So there's the ability to actually, it seems like, reach the president through advocacy, some avenues. So the diversity, their first question here is, will there be a green card lottery going forward? Any news on that? I've not heard anything about the diversity immigrant visa lottery, which I believe is what this person is answering. If I recall, Mike, wasn't it taken away during the Trump administration? The first one? Yeah.
There were attempts to do it, but it
Yeah.
still
Yeah.
exists. It's not getting any traction in the administration right now, but it may be on their issues list, but it's pretty far down.
Cool. Next one's a little too, from honest opinion, it's a little too specific to answer.
Yeah,
Any update?
reach out to us
Reach out to
independently.
us directly if you'd like a consultation. We're happy to answer that question. Any update on the final D/S rule that we published? I think this is referring to the F and J1 rule that we mentioned at the beginning. F and J1 students this is highly technical, but get technically what's known as duration of stay. This would just change it to a determined period in which they would be allowed to stay. Technically, there's a bunch of things that fall out from status and non-status from that. Mike,
Yeah.
any additional points? I
I,
don't think we've heard
I, I
anything.
no, this is an educated guess. I think they would try to have it in effect by next academic year, so that would be sometime this summer. The rule would come out late spring, early summer. So the rules typically have a 60-day effective date. The rule is effective 60 days after publication in the Federal Register. So I would think that if they're going to try to implement this for the next academic year, August, September, they would do it 60 days in advance of that.
Yeah. We talked about the potential proposal in 2026 to rearrange how employment-based green card processes are done. This question here is asking, have we seen a tightening on approvals in the EB1 and EB2 national interest waiver categories leading up to this? We file a fair number of these. I don't believe we have at the moment. We have kind of a dedicated team that handles these inside the firm, and we haven't seen any significant changes in approval rates, perhaps more RFEs, but this category was always pretty RFE heavy, given it's more of an art than a science writing these EB1 national interest and extraordinary ability petitions. The visa integrity fee, if employees travel back to their countries of citizenship and obtain updated visa stamp, will the fee be charged to them at the consulate abroad? Is this guaranteed? Does it have to be reimbursed by the employer? Mike?
Yeah, I mean, I think the structure that I expect will happen is that the payment will be made after the visa is issued. So it won't be charged. You won't be charged this fee until it's been determined that you're eligible for the visa. They'll probably require you to use the pay.gov website abroad to pay the fee. And then once the fee is paid, the visa will be issued. Is it guaranteed? Yeah, well, this is in effect now, technically, right? It's technically in effect since October 1st. It's just that it hasn't been implemented because they haven't been able to figure out all of the process. So that is happening. That will happen some point in 2026. My expectation is probably Q1. Does it have to be reimbursed by the employer? No, I don't think there's an obligation in that regard. Although there are clearly business arguments on both sides of it.
Yeah, Mike, we have some good questions here. You want to go 2 more minutes? I think we're
Oh,
just at spot there.
I'm fine. Yeah.
Yeah. So, question for one of our attendees: for the wage cap of H-1B applications coming up, I'm assuming you're talking about the lottery. Can we know the exact, essentially wage levels or numbers for specific roles? No, unfortunately, we can't. I mean, The proposed rule right now says whatever wage level, if you're wage level one and you're entered in the lottery, and I hope this is the issue you're talking about, you get one entry into the lottery. If you're wage level four and you're entered in the lottery, you get four entries into the lottery, thereby weighting higher wage level applications to be more likely selected. I hope that answers your questions there, but unfortunately, we don't know any other specifics right now around that.
Yeah,
Um,
it'll
Probably
be
until January. Yeah,
it'll be salary and location specific, right? So we'll
yeah.
have to, so it'll depend upon the job offer, the salary, and the place where the job is located. So
Yeah, I mean, and to be clear, a wage level four for a software developer in Montana is much less than a wage level four for a software developer in San Francisco. So it really is going to depend on where exactly the work's being performed and what wage level would apply or what the employer could bear. Next one's a little specific. Maya,
yeah,
do you recommend having a separate file for PAFs? So the public access file needs to be created every time an LCA is filed with the Department of Labor, even if it's revoked thereafter. We create these and keep these as separate individual files for each LCA tied to each case that we file. So yes, I think separate files for PAFs is welcome. It also just kind of depends on how you file the LCAs. We typically, in most cases, because we file one case at a time for one person at a time, a public access file will likely have just one set of documents in it. If you have public access files where you have multiple individuals that are being sponsored in the LCA, that could change slightly. You have to have a list in there and things like that about who's using which, how many numbers you've listed on the LCA. But overall, I would highly recommend taking a look at your public access files. Should have one for every single LCA that's filed. Well, generally, that applies to one per case that's filed. But again, if you file an LCA for multiple positions, which is possible, and you use that same LCA on six or seven different H-1Bs, you would have one file for potentially six or seven cases. Even in that stage, though, I would still probably have a separate file for each case. Mike, what are your thoughts?
no, I agree. I've been a big fan of creating separate PAFs for individuals because often the investigations may be specific to a particular individual or location. So
Yeah, exactly, right. And you don't have, or just a particular individual in general, right? And you don't want to have
right.
to give out, well, you actually probably would anyways, just to survive the audit. But what is the timeline to clarity around the 100K fee will apply, whether the 100K fee will apply in 2026? I think we'll know in January, probably at some point, right, Mike? There's
Right.
multiple litigate cases being litigated right now in multiple federal districts that are kind of, racing to an injunction here.
Yeah, technically it took effect on September 21st, but there was no guidance. So right now we're seeing a couple of RFEs to cases where it was a straight consular notification of a new H-1B employer, but there has been no really consistent application of the rule yet by USCIS. I think the target is April 1st and the fiscal 27 filing season.
Yeah, that's a good question. We have an anonymous attendee asking, what does accelerate sponsorship timelines in parentheses mean in regards to stricter eligibility requirements in the EB1, EB2, and EB3 category? That immediately comes to mind is if they're going to change the way that they're going to do green cards in the future, it might be better to start a green card now in one of these categories because any change will likely affect future petitions and not ones that are already in process.
Right.
Mike, your thoughts there?
Yeah, no, it's normal, I think, for most companies to have sort of sponsorship policies when they would begin the permanent residence process. And it could be 6 months, could be a year, it could be 2 years, could be more than that. And what I'm trying to really highlight here is that if you can get your application filed and accepted and feed in under the current regulatory regime, it may be beneficial to consider doing so. So if all you're doing is saying, well, we've got a 1 year policy and we're 6 months away or 8 months away, we have a 2 year policy and you're a year away, and you're going to sponsor the person anyway, because that's what you normally do. This might be a time to look at your exception rules in your sponsorship policy.
Yeah, I agree. The next one's a little too specific when it comes to which months you can't travel after the upcoming lottery. That will be highly dependent on what your status is, when it expires, whether you're going to be in cap-gap or OPT or OPT STEM. Unfortunately, we can't answer that without additional information. So feel free to reach us out, contact us on our website, and we can answer that question for you in a consultation. One follow-up, which I think is important here. Should public access files be electronic or physical or both? I, personally always push for electronic files because they are more resilient and redundant. If you have, obviously most of us are using cloud-based systems right now for software or document storage. So you have, if your office burns down, God forbid, you don't lose all your physical public access files in it. They're stored on some server, across the world in the Philippines or something like that. So you can always access them at any time. Mike, do you have an opinion there?
No, I'm a strong proponent of electronic files too. It's actually easier because often you can sort the databases and do processing of them based upon the information in your HRIS system. So there are lots of things you could do when they're electronic that you just can't do easily with paper.
Yeah, it's fair.
You know.
I want to two more questions here, and I think we're about 6 minutes over. So, sometimes writing public comments feel hopeless with the administration. What benefits are there to submitting a public comment on the proposed rules? I still think it's of value. Public comments, could potentially in the future be used in litigation at some point, for, public policy arguments. I think, that's important. I also think what is really important that a lot of folks are passing up is membership in things like the U.S. Chamber of Commerce, these other like larger pro business immigration organizations. The U.S. Chamber of Commerce is all over the place on issues. It's neither conservative nor liberal. It advocates for business owners, and business rights and staffing and employees and things like that. So it could very much be on the wrong side of a tax issue that a lot of people disagree with, but could be very much be on the right side of an immigration issue that most people agree with. So I think it's important to fund these organizations, and because they do have greater access and advocacy in front of Congress as well as the administration. Is an individual person going to be heard by the president? No, but the president of the U.S. Chamber of Commerce might be able to get a meeting with Donald Trump at some point. Mike, your thoughts?
Well, anonymous, being someone who's participated in dozens of regulatory comments, I feel your pain. I really understand. Sometimes it seems like we're spitting into the proverbial wind here, but it's important to note that the Administrative Procedure Act requires the agency to review and respond to every comment issued in connection with the proposed regulation. So there were over 11,000 comments to the weighted selection proposal, and the agency is right now is slogging through that. I mean, my understanding is they've actually taken additional lawyers to review the comments so they can hopefully meet their goal of getting this in effect. So there's a part of this that is sort of throwing a lot at the machine, so it sort of slows the gears down a little bit. But yeah, it's also creating, as Matt said, a basis for future litigation in terms of the agency not following the APA and properly reviewing the comment.
Yeah, then finally, alternate wage can also there is the USCIS, or the Department of Labor publishes wage levels, the prevailing wages. You also have the ability to use alternative wage surveys in some circumstances. Now, this has been more limited in recent years, but again, this is sort of a cat and mouse game between the administration and immigration attorneys in the community. We have a lot of really smart, well-educated, creative attorneys in the community. And to be honest, every move that the administration makes is going to be a counter move made by us as counsel to preserve the efficacy and the continuity of your immigration program. Do you think we will be able to use alternative wage surveys against additional wage rates or wage level increases, Mike, or anything like that? I think that's probably where I would land. Let's see if we can use these alternative wage surveys against
Absolutely. Yeah.
against these absurd increases in wage levels.
You're not going to have any other. You're practically, if that rule comes into effect, you're not going to have any other choice, frankly.
Yes.
For most of your employees. Yeah.
And like the Department of Labor has selectively accepted wage surveys. They have published data around what they will and won't accept with regard to a wage survey. I would imagine that there'll be a lot of those submitted, and that will probably turn into litigation at some point.
Yeah, there's very old guidance on acceptable alternate wage surveys, which may end up being revised and changed over the years in response to the sort of action response. So yeah, we'll be using alternate wage surveys because we have no other choice. Expect the agency to know that and respond.
Yeah, there's a lot of tools in the toolbox as immigration attorneys here. We've all been doing, a lot of us have been doing this for a very long time. So there's lots of creativity available. We're going to have to run. It's about 10 minutes over today. We hope that everybody got value out of this. Is why we continue to do this every month, is to try to add as much value to employers and individuals as possible. If you have any questions about what we talked about today, feel free to reach out to Mike or myself. You can always reach out to us via our individual emails, excuse me, or on our contact us call to action on our website. We hope everybody has a wonderful holiday season. We will be back in January. to
Yes.
discuss hopefully some progress on some of these initiatives and give even more clarity than we were able to provide today. Mike?
Yeah. Yeah. Thank you all. So many of you stayed on until the bitter end. So I appreciate that. And yeah, happy holidays.
Take care, everybody.